gentleman had some additional questions to...
Thank you, Mr. Chairman. I would like to call Chris Barnes as a witness. And if I understand the procedure, he would...
Your name, please?
My name is Thomas Burns. I'm with the Canton City Law Department. I represent the City of Canton. The City of Canton owns real property surrounding this site.
Thank you.
That's our connection to this case. And I believe Mrs. Chris Barnes, and I believe he was sworn.
Yes.
You want to state, tell the commission about yourself, what you do, and what your experience in education is very quickly.
Sure. I'm a licensed professional civil engineer in the state of Ohio. I have worked I'm the assistant city engineer for the city of Canton, and I've specialized in stormwater drainage my entire 19-year career. I'm also certified as a professional in erosion and sediment control. I'm certified as a professional in stormwater quality. I'm also certified as a municipal separate storm sewer system specialist. Essentially, I'm a professional stormwater nerd. I've worked for Stark County engineer. I've worked in the private sector, and I've been with the city of Canton for 9.5 years. I've seen a lot of flooding throughout the county, and especially in the city of Canton. This particular area is an area of concern, specific concern of mine, with the shared detention basin between Montebello Estates and First Friends.
When you say this area, is there can you describe it a little bit more?
Yeah, so the core one runs right in the middle of a detention basin. There is a 176-acre watershed that drains to this detention basin. Much of the water drains from North Canton and the city of Canton.
And that water basin is, where is it in proximity to this application site?
It's immediately south.
And have you had a chance to review the application that was filed
Yes.
in this matter? And so what are your thoughts on this in terms of drainage issues?
Well, I have 6 points that I'd like to bring up with respect to the big picture drainage concerns. Since First Friends and Montebello Estates both were constructed in the early 2000s, there has been several flood occurrences where water has gone over Market Avenue and has flooded downstream properties in the city of Canton. So with respect to that, the 6 points I'd like to bring up are on the original detention basin plan for this basin. It shows a wetland area. There's a note on the plans that mentions a permit from the Army Corps of Engineers being granted to First Friends to allow for the filling of the wetland area. This is extremely concerning to me. We have not seen this permit, and it's unclear if this permit was ever granted. Even if such permit does exist, I can only presume it was granted without flood control as a consideration from the Army Corps. That's not where their interest lies. Their interest would lie only with respect to impacts to the wetlands. I cannot stress enough the importance of the detention basin and the need to maximize its storage capacity for flood control. The second point is there have been concerns over the past several years of filling and encroachment of the detention area. I have 2 separate sources of photos over 2 different time periods that show filling in this area, some of which appears to be in the vicinity of the proposed cell tower location. And this is key because it appears that the proposed tower is close to or perhaps even within the area that floods when water overtops Market Avenue. So in the application to the Planning Commission, it states, quote, the existing site grade is low area and will require a slight amount of fill to bring the site compound up to finished grades, unquote. The cell tower grading plan that was recently submitted on December 4th shows some proposed fill. So the concern is twofold. Number one, that either changes to grades in the detention area have already occurred in the past in this area, or number two, that additional fill will occur in the area that was originally intended to flood. Either of these result in decreased storage capacity of the detention basin. In addition, in comparing contours from 2000 to 2006, there's been approximately a 25% net reduction in storage volume in the detention basin. Part of this is in the vicinity of the proposed cell tower. So any past, present, or future additional filling of the detention basin or in the immediate vicinity takes away much needed storage capacity in the basin. The third point, under section C in the application, it states, quote, "The proposed site location is in an area that is not going to be developed by the church. The area is open and adjacent to an existing wetlands and storm detention area," unquote. However, the June 2006 master plan for the church shows future soccer or football fields or parking within the same area, which is part of the detention basin. This is also very concerning because it would result in additional fill in the detention basin, which will then reduce its storage capacity and subsequently cause an increase in flooding downstream. My fourth point, the watershed or the drainage area to the detention basin consists of runoff from approximately 176 acres, much of which is from North Canton, from First Friends, Monticello, and other areas even north of 55th Street. Since all of this water eventually drains into Canton, and there is a history of Market Avenue overtopping as well as residential flooding in the downstream vicinity, collaboration needs to take place between North Canton and Canton in the review and coordination of any and all future development that occurs not just on First Friends property, but in any of the undeveloped portions of the watershed draining to this point. Fifth, in my opinion, although the criteria originally used to size the detention basin may have been allowed at that time, it is not adequate for today's standards, and we know that because of the flooding that has occurred. Ideally, the detention basin should be redesigned so that it can manage runoff from the 100-year storm from a fully developed watershed. This means that the detention basin should be redesigned and additional storage capacity should be provided to bring it up to current standards, thus alleviating the flooding problems. And the last point, the detention basin serves both City of North Canton and City of Canton property. However, the flooding affects City of Canton properties only. As such, more than $2.5 million has been spent in several attempts over the past few years in Canton to alleviate the flooding in the downstream vicinity. The downstream storm sewer in Plain Center Estates has been replaced with a larger system. An additional detention basin has been constructed approximately a half a mile downstream. Additional storm sewers have been installed on Cedar Glen, which is a City of Canton street immediately downstream of Market Avenue. A lot of time and effort has been invested into residents with respect to the flooding. In addition, many residents have invested their own money in attempts to alleviate flooding on their own properties. The point is this, all of this is still not enough. Health, safety, perceptions, and reputations are at stake. The flooding isn't just Canton water, it's not just North Canton water. The existing detention basin does not work right with the way things are today. Any proposed development, it needs to be redesigned to account for the latest master plan for the church, and it needs to be made bigger. Any proposed development near it prevents that from happening. All available undeveloped space within the vicinity of the detention basin is extremely valuable and should remain available until a redesign occurs, showing whether it's okay to use that space for development or if that space is needed for the additional storage of floodwaters.
You used the term master plan on the church. Could you just very briefly explain a little bit what you mean by that? And what the purpose of it is?
Sure. Back in 2006, we were provided a copy of a master plan for the church showing the potential future build-out of the church.
Why were you provided? Was it a requirement?
No.
Was it courtesy?
No, this was in response to drainage complaints and flooding. We were able to meet with an architect that, on behalf of the church, and he provided that.
Thank you.
Do the attorneys further?
Yeah, I do, Mr. Chairman, thank you.
Sure.
Good evening, Mr. Barnes. You probably heard earlier, my name is Jim Matthews, I'm representing Tower. I just have a few questions for you. It's my understanding that your primary criticism relating to watershed capacity is over this shared detention basin between the properties in question, right?
Yes.
And if I understood your testimony correct, you're suggesting that at some point in time in the future, that basin needs to be improved in a comprehensive fashion to handle a substantial amount of acreage that is drained into that location.
Yes.
It's not simply the First Friends site that's creating any flooding at the basin, correct?
They're not limited to them only. No, they are part, it's a contribution from them as well as the rest of the properties in the watershed.
And you had mentioned that the watershed there is 160 some plus acres,
176.
176 that drains into that particular basin.
Yes.
Did you do any type of calculation on the anticipated additional runoff that would be incurred if this shelter is built, the platform, and the pilings are run and the towers installed?
No, I did not.
Have you seen the letter provided to the Planning Commission from Mr. Benikas, the local North Canton engineer?
Yes, I have.
And in that particular letter, Mr. Benikas' position is that the plans provide for very minor grade changes to the site, correct?
Yes.
And only minimal change to the surface porosity is stated in his letter as well, correct?
That's what it says.
And in light of those 2 points that he stresses, he then concludes in his letter to the commission that the effect to the drainage runoff is negligible.
That's what it says.
And in contrast, you haven't done any calculation of whether the runoff from this facility would be negligible or something in excess.
In and of itself, I do not have concerns about the development of a cell tower. We see plans for cell towers every once in a while as site plans. And those do not create a problem. What I'm trying to bring awareness to is the location of it is within an area that is needed for flooding currently.
What we talked about, the basin needs to be improved someday by a comprehensive sense to improve drainage of this large area. That burden certainly should not be borne by just the First Friends site, correct?
I believe that collaboration is needed between Canton and Washington.
That's all I have, Mr. Chairman. Thank you.
Tim, you have?
Yes, sir, and my questions for you, Mr. Barnes. I hope that these don't sound critical because my position is, I hope you understand, the city of North Canton really doesn't have a stake in this other than it wishes to get it right in looking at this and making the determination. And what needs to be presented to our planning commission is evidence. And although we've had numerous comments from concerned residents, and we certainly welcome those, and we understand their concerns, they have to rely on the planning commission as with evidence. And opinions, conjecture, what ifs, and so forth, they're not permitted to take that into consideration. And one of the speakers was right on point that the FCC is really clear with issues that a planning commission may consider in reviewing a site plan and conditional use for a cellular tower, and which issues that it may not consider. And straight up front is the issue of, is that actually evidence? Is that substantial evidence that they can rely on? So I hope you understand, some of my questions for you are in relation to your testimony and the evidence that you may wish to present so that they can make the decision. Now, you had mentioned that there's been a 25% reduction in capacity of this water detention basin. Is that correct?
Yes.
And what have you brought as evidence, other than your testimony, that you can demonstrate to them this 25% and perhaps what that means? What does that mean perhaps in a normal storm in the rainwater capacity that they would have in that area?
I have a printout, a GIS printout showing contours from the year 2000 and also showing contours from the year 2006. And I apologize if you can't see everything, but
Okay.
everything that's highlighted in blue represents the inundation area that occurs when the storage area is at its peak level, right when Market Avenue overtops. That's based on 2006 contours. The pink area around it is the same elevation in 2000. So it's somewhere around elevation 1114 when Market Avenue overtops. I've highlighted the same elevation in both the year 2000 and 2006, and I've done a calculation to show the area, the storage area that's shown in pink represents a 25% net reduction in available storage volume in that detention basin. What I've also shown is the footprint of the proposed cell tower compound. A portion of that is within the flood inundation area from the year 2000. So it's concerning to me that regardless of whether the fill occurs with the cell tower, it appears that fill has occurred at some point over time. Any additional fill that occurs in this basin is that much more water over Market and flooding our constituents downstream. I'm sorry, did that answer your question?
Do you wish so that they can understand how you made your calculation reduction?
Sure. We have computer software, CAD, with these contours within it, and we can calculate the areas of the contours and the depth they represent and do a volume calculation to show the volume available in the basin in the year 2000 compared to the volume available in the basin in the year 2006. And we simply subtracted the two to come up with that 25% net reduction.
Okay, and how does that relate to, say, 2015? Do you know how those would change at this point?
I don't know.
Okay, so we're looking at what was there 9 years ago, and it's unclear how that may have changed.
I do have photos that were emailed to me from a constituent whose mother lives immediately downstream across the other side of the Market. The photos were emailed to me this year that shows filling within the First Friends parking lot, and it refers to as First Friends parking lot expansion. This one does show some dirt being brought in, and it's having been out there in response to this, it's right in that area where the proposed cell tower is.
The date of that?
Well, the date of the email is July 9th. I do not have a date for a specific photos.
Mr. Chairman, we'd like to have them marked as exhibits.
Well, I guess before you do that, I'd like you, if you would, to authenticate that as an exhibit for our commission and not just take it on face value that a resident's photograph.
I could get the dates from the electronic.
We actually need it here. Just for those of you that the concern of you'd like to bring something back, please imagine this because it's an adjudicatory hearing. You had the opportunity to submit evidence, testimony, documents, and so forth. It's as if, try to rationalize it. Imagine attending a trial and someone say, how about I get back with you tomorrow, on this? And I don't wish to make light of it, but there's a burden on the commission in what it can and can't do, and what it can't do is permit you to come back at another time to shore up an issue with evidence. If no one wishes to authenticate, I would object to the admission of those, but if the chair wishes, you can proffer that, and then that can be decided if the issue's appealed.
Well, we'll accept it as it is, condition upon with the conditions that Mr. Fox has placed on that.
I have no questions.
So if you want to pass it on to the commission to look at it. The other attorney representing the homeowners, you have any questions?
No, I do not.
Okay.
Mr. Chairman, I'd like to clarify one issue that Mr. Fox has brought up here. Mr. Barnes, the two dates that you used for the aerials,
Yes.
why did you use those dates?
Those were files that we have available to us.
All right.
Thank you, sir.
We would like to proffer those.
Yes, sir, absolutely.
Okay, with that, everybody's had the opportunity to speak. The attorneys have had the opportunity to question
I
witnesses.
think we have one more.
Pardon?
I said I have another witness.
Okay. Let him finish. Go ahead.
No, I am the other witness.
Oh, okay. All right. Proceed.
Want to identify yourself, Daniel?
Yes, my name is Evan Mack. I am an attorney at Zangus Placus Manos in downtown Canton. And I am a homeowner in the vicinity that we're speaking of here this evening. And I'm also the council person for the city of Canton, Ward 8, which includes the Montville neighborhood.
I understand you have some comments,
Yes.
things you want to bring up.
Yes. And thank you to this commission for being so patient with your time tonight. I know this is a challenging issue with a lot of people feel very passionate about. And I would like to discuss with this commission's opinion, some specific facts pertaining to your important analysis.
I have a question. Is there a time limit on this?
No,
On this, no.
Unfortunately.
And you are under oath?
Yes, I am.
Thank you.
I am.
officer of the court is always under oath.
I took the oath anyway, just out of
Yes,
regard
sir.
to
Yes, sir.
And with the commission's permission, I'd like to hand out some evidence that we were looking at together. I've given a copy to Attorney Matthews. I'll wait for those to look over.
You have another copy of this?
Yes, we can give you a copy. Director Fox, I thought
I understand. Oh, happens all the time. Thank you.
the first point I want to talk about with this commission's permission is the obligation under your ordinances for these cell phone towers to co-locate. We've heard that phrase some tonight. And what co-locate means is when you have a tower that's been constructed by a particular telecommunications carrier, they have an obligation under your ordinances to join together. If Verizon builds a tower, then if AT&T wants to have service in the area, they have an obligation first to go to the tower that's constructed by Verizon. And when we look at your ordinances, at the first box down, the first page, your ordinances state they're actually intended to promote the co-location. And that in the submission requirements that Power Code was required to provide in this case, they had to demonstrate that co-location was not available to them when they submitted this application to you. On the next page, you're going to see a photograph of a water tower. That is a water tower owned by the city of Canton. That is the Brentwood Water Tower on Market Avenue. If you'll notice on the photograph, on the first page, you'll see little indentations just below the head of the water tower. Those are cell phone antennas. And if you go to the next page, this is an aerial photograph that shows how far away the city of Canton's Brentwood water tower is from the location chosen by Power Code. And it is exactly 0.56 miles, 2,200, approximately 2,000. On the following page, an actual copy of our lease, the city of Canton's lease, for this cell phone communication facility on our water tower. It is with AT&T, approved by our legislative body in a matter of public record. For the rent of the lease is actually a matter of public record, but just an abundance of caution, I've included the entirety of our lease with AT&T. I can say to this body, as a member of Canton City Council, and the body charged with approving these types of leases, we've not been approached by Power Code with respect to placing co-located facilities on our water tower. And I believe I can speak for the service director, who is the statutorily charged person tasked with negotiating these leases. Service Director Barclays, who's in attendance here tonight, has not been approached either. Under your ordinances, that was something that Power Code required to explore. The next point I would like to make to this body concerns utility easements, or utility easements. Under your ordinance, and I'm now looking at a page that begins after the lease of the references. It has other boxes in there. It's a summary of the ordinances. Under your ordinance, documentation that shows the power company in this case has authority to construct a facility is required to be submitted with the application. This body heard a back and forth with the church tonight, articulating their position that they did not believe there was authority under the interpretation of the documents the power company did. That's under the same applicable provision. The city of Canton owns property, real estate, directly next to First Friends Church. And that's a sliver of property in this yellow parcel that runs right up Market and goes up to 55th. This is not an easement for a roadway. We own this property free and clear and fee simple. As a part of their plans, and their under Power Code, and constructing the cell phone tower application, their site plans, and all of the documentation, they show a utility easement going across our property. They have not submitted a written easement approved by Canton City Council, giving them this authority to build within our land. We brought this to the attention of our law director, Mr. Burns, brought this to the attention of Power Coast Council by letter, and the response was in sum or substance, well, we technically don't have an easement, but Canton City Council can't unreasonably deny an easement if one asks for it. Well, certainly we cannot unreasonably deny someone access to utilities, but we can reasonably deny. And that's the prerogative of a legislative body. And that is an analysis that Kansas City Council has yet to do, and we've not been asked to do that yet. Our law department has not been asked about an easement, and neither has our service director. There are real concerns that could be waived by our legislative body should we be asked for an easement. And those include the actual elements of the parcel and what it is designed to do right now in our stormwater runoff configurations. Now, I've included in the packet of materials documentations that reflects the actual drainage facilities on this property. And that's in the second pages there. Our legislative body would have to weigh, from guidance from our engineers and other professionals, what impact a utility easement trenching would have. And as a part of our legislative process, it's established by statute that we have to review plans. The City of Canton City Council has to review plans when we do this in order to approve the easement. We can have fees if we think there's going to be costs that have to be offset. And we can even have require as a part of giving the easement that the person installing the utilities indemnifies for any increased cost of the cap. The point of this is that this is not happening. And it was required to have happened per your ordinance. And the final document approved by City Council was required to submit the application. And it wasn't. I certainly, to bring my comments to a conclusion, I certainly share, obviously, my constituents' concerns about flooding, and I can assure you they are very real. The photographs that were talked about by our civil engineer, Chris Barnes, I too received those photographs. They're from Barbara Kirkland, and she's someone whose house is flooded almost every year now when the detention basin overflows. The ordinances, when you weigh these different considerations in approving this application, under 1145.02, these are factors that, respectfully submitted, should be considered as to whether the tower company, in submitting this application, has demonstrated that there will not be adverse effects to the property owners. There will not be adverse effects to the property owners. City Council of the City of Canton wants to do this analysis. We want the tower company to come to us and allow us to engage in the legislative process as to whether we should grant them utility easement. I respectfully submit to this commission that their application should not be approved until that happens. And I really appreciate all of the time.
Yeah, Mr. Chairman, thank you. Good evening. How are you? Good. Just a few questions for you, primarily relating to the proper public policy of the state of Ohio. First of all, to encourage economic development, isn't it? It is. It's a statutory enactment from the General Assembly that that's the general public policy of the state. It is. Concomitant with that statement of policy, it's also a clearly stated policy in the revised code that it's the policy of the state of Ohio to promote the extension of utility services to allow properties to be economically developed. You would agree with that, right?
I would.
You know that there's another section of utility law that provides that a city is not permitted to unreasonably withhold consent for a rational, reasonable extension of utility services, right?
That is true.
Are you aware of the fact that the location of this proposed tower is on a site that's already developed that has utilities?
You mean the entire parcel?
There's a church facility already on the parcel, right?
Right. Well, you need utilities, or else you would have reflected utility easement going through our property.
My question is, you know there's a church already built on the site, right?
Yeah.
And it has utilities. You would accept that, right?
Of course.
Wouldn't it be irrational to allow on the site utility services to one location and one application, but somehow deny it to another application on the site?
I suppose, first off, that's a decision for the city council of the city of Canton. When you factor in trenching over our drainage ditch, which is why all these people are in this room tonight, whether the city of Canton's decision to approve it or not approve it, that's what the legislative body decided.
It may be for some later consideration, or it may be for a court to determine, correct?
If Canton City Council approves it, and the power company is so offended by our disapproval that they would like to sue the city of Canton's council for a judge to decide whether we unreasonably deny trenching over our ditch, that would be your power company's prerogative.
And there's a provision of Ohio law that makes it clear that the access to utilities within roadway right-of-ways or other interests held for roadway purposes can't be discriminatorily denied. It can't be denied based on some economic or competitive reasons. The essence of the law is that utility extensions have to be fair and reasonable to every applicant. All right? You would agree with that? You mentioned to the members of the commission your comments about the plat, the site plan that has been submitted for their consideration. It's in the packet as number 4. I only have one copy. I'll just read that. You have one? You indicated your understanding that the drawing provided for the easement extending across the Canton parcel, right?
Yes.
Actually, the easement depicted in the site plan extends to the parcel, but not across it. You see that? The heavy dark line or dashed line is the depiction of the easement, isn't it?
I'm trying to interpret your drawings. Do you have a site plan that shows the utility easement that stops and isn't connected to the actual utility?
I'll show you here. On number 4, the site plan, the heavy dashed line ends right where the Canton property line is depicted, isn't it?
This line,
The heavy dashed line ends exactly right there at the property line, doesn't it? And the lighter dashed line has nothing to do with the description of the easement. It's the location of the line in relation to the center of the margin.
I can't do that. It says 10 feet utility easement. Why would you have the utility easement stop at the utility?
Because the utility providers are the parties that are going to be entitled to use the right-of-way, correct? We don't need an easement. We need an easement to reach where the utilities will be, right?
Either it's the utility or the power company, somebody's going to have to meet the city of Canton, and right now you don't have it.
And as long as we get to the property where the utilities will be installed, we will be connected, correct?
Who's going to apply for the easement to then install you over our property?
I'll submit to you the utility companies are going to apply to North Canton, who controls its roadways within its jurisdiction, for permission to extend utilities to this property.
Well, that would be a change in the law. I don't think that's going to be the case, but that's your opinion.
Well, we'll see if that's the case, right? Your interpretation of statutes and my interpretation of statutes appear to be in some conflict.
The language is pretty clear.
Well, you don't dispute that this easement, right-of-way, or property owned by Canton is strictly for highway use and purposes, isn't it?
I would dispute that. It's obviously for drainage purposes.
Why was it originally acquired?
It's part of the extension market.
How was it originally acquired?
Through the eminent domain proceedings, we paid $130,000 from it. We paid, $29,000 from the Hoover Company in the 70s, which is the equivalent of $120,000 today. That was a stretch.
There were court papers filed asserting why this roadway interest was necessary, correct?
They're part of this commission's package. That's true. The entirety.
Is the complaint part of the package?
No.
Let's take a look at the complaint, okay?
Sure.
Pass those around. I'll represent to you, Mr. Mack, that this is an authentic copy of the complaint for appropriation related to the Canton property at issue, taken from the files of the Common Pleas Clerk's Office.
All right.
If you flip to page 2, in paragraph 4, it clearly states that this appropriation of real property was, quote, for the purpose of use for the Market Avenue widening project, close quote. Did I read that accurately? 3 or 4 pages in, you'll see a resolution from the city of Canton. You see that page?
You see it?
Was a resolution adopted, represented to the court as the reason or rationale for Canton acquiring this interest, right?
It's a resolution of Kansas City Council.
And it states as part of the header to that document that the necessity is for the Market Avenue widening project, right?
Sure, I'm not disputing, that's why we acquired it.
And it otherwise states in here it's for the, quote, purpose and use of the Market Avenue project.
Okay.
You agree with it?
I agree we acquired it for an extension in 1975. I don't think there's anyone who can dispute that.
So there's no question that interest bears a direct relationship to highway purposes. Fair to say, right?
Our ownership of the property is clearly related to roadways, right? Yes.
All right. That's all I have. Thank you, Mr. Chairman.
Any questions? Tim? Okay. Are you finished, sir?
Yes, thanks.